What happens if you are arrested by the police? That's exactly what we'll discuss today. Let's begin.
Imagine you're walking home from work. A police car pulls up beside you. An officer steps out and says, "Sir, I need to talk to you for a moment. You haven't done anything wrong. You're not under arrest." But then the officer says, "Stay where you are." At that moment, something important has happened. You may have just been detained. Most Americans hear the words detained and arrested and think they mean the same thing. They don't. And not knowing the difference can lead people to accidentally give up their rights, make a situation worse, or even face criminal charges they could have avoided. Today, we're breaking down exactly what happens when police detain you in the United States, what officers can legally do, what they cannot do, and what rights you still have. This is information every American should know. What does detained actually mean? Being detained means police have temporarily restricted your freedom to leave. In simple terms, you are not free to walk away. However, you are not necessarily under arrest. Under the Fourth Amendment, police generally need a legal reason before they can detain someone. For a temporary investigative detention, officers usually need what's called reasonable suspicion. Specific facts suggesting criminal activity may be involved. This is commonly known as a Terry stop based on the Supreme Court case Terry v. Ohio. Think of detention as the middle ground between a casual conversation with police, a full arrest. If an officer simply approaches and asks questions while you're free to leave, that's usually a voluntary encounter. But if a reasonable person would believe they are not free to leave, the situation has likely become a detention. How do you know if you're being detained? Sometimes police clearly say you are being detained, but often they don't. That's why one of the most important questions you can ask is, am I free to leave? If the answer is yes, you can generally leave peacefully. If the answer is no, or if officers physically prevent you from leaving, you are likely being detained. Many people make a critical mistake here. They assume that because they haven't been arrested, they can simply walk away. That can quickly escalate the situation. Whether you believe the detention is lawful or not, physically resisting or attempting to flee can create additional legal problems. Why can police detain someone? Police cannot legally detain people based on a mere hunch. They need reasonable suspicion supported by specific facts. Examples might include matching the description of a suspect, being observed near a reported crime scene, acting in a way that appears connected to criminal activity, information provided by witnesses. Reasonable suspicion is a lower standard than probable cause. That's important. Police need probable cause for an arrest, but they only need reasonable suspicion for a temporary detention. What can police do during a detention? Once detained, officers can investigate the situation. This may include asking questions, checking identification in some situations, running records checks, verifying information, confirming or eliminating their suspicions. The purpose is simple. Police are trying to determine whether a crime occurred or whether you are connected to it. Many people think, if I'm innocent, I'll just explain everything. That sounds logical, but innocence does not guarantee that speaking extensively helps you. People often forget details, misspeak, or accidentally provide information that gets misunderstood. Do you have to answer questions? This is where many people get confused. Generally, the Fifth Amendment protects your right to remain silent. You do not automatically have to answer investigative questions simply because you are detained. You can calmly say, "I am exercising my right to remain silent." That is a lawful statement. Notice what works best. Stay calm, stay respectful. Don't argue, don't raise your voice. Being silent is often safer than trying to talk your way out of a situation. A surprising number of criminal cases are strengthened not by physical evidence, but by statements people voluntarily make. Do police have to read you your rights? A lot of people believe police must immediately say, "You have the right to remain silent." That's not always true. Those are called Miranda warnings. Miranda warnings are generally required before custodial interrogation, not every detention. A temporary detention or traffic stop often does not require Miranda warnings. This is where people get into trouble. They think, the officer didn't read me my rights, so anything I say can't be used against me. That is often incorrect. Many statements made during a detention can still be used later. The safest assumption is that anything you say may become evidence. Sometimes, but not automatically. A detention and a search are not the same thing. Under Terry v. Ohio, an officer may conduct a limited pat-down if they reasonably suspect the person is armed and dangerous. A frisk is not supposed to be a full search for evidence. Its primary purpose is officer safety. Many people incorrectly believe police can search anyone they detain. That is not how the law generally works. A lawful frisk requires additional justification beyond simply stopping someone. What about traffic stops? Many people do not realize this. When police pull over a vehicle, everyone in that vehicle is generally considered detained for the duration of the stop. That means the driver is detained. Passengers are also detained. The officer can temporarily control the scene while investigating the reason for the stop. This surprises many passengers who believe only the driver is involved. Legally, traffic stops are treated as seizures under the Fourth Amendment. How long can police detain you? A detention is supposed to be temporary. Officers must generally investigate using reasonable and efficient methods. The stop should not continue longer than necessary to address the reason for the detention. There is no universal timer. The law does not say exactly 15 minutes. The law does not say exactly 30 minutes. Instead, courts look at the circumstances. The longer a detention continues, the more likely courts may question whether it effectively became an arrest. When does detention become arrest? This is one of the biggest legal questions. At some point, a detention can become so restrictive that it effectively turns into an arrest. Courts may consider factors such as use of handcuffs, number of officers present, amount of force used, length of the encounter, degree of restraint on movement. There is no single factor that automatically changes a detention into an arrest. Courts look at the total situation. An arrest generally requires probable cause, which is a higher legal standard than reasonable suspicion. Should you argue with police during a detention? No. Even if you believe the officer is wrong, even if you believe your rights are being violated, the roadside or sidewalk is usually not where legal disputes get resolved. Courts resolve those disputes later. Arguing aggressively often creates more problems than solutions. The better approach is stay calm, be respectful, avoid sudden movements, do not physically resist. Clearly state that you wish to remain silent if that is your choice. The biggest mistakes people make. Mistake number 1, talking too much. Many people think if I explain enough, they will let me go. Sometimes that happens. Sometimes it does not. Every additional statement creates another opportunity for misunderstanding. Mistake number 2, lying. Lying to police can create serious legal consequences. If you are exercising your right to remain silent, remain silent. Do not replace silence with false statements. Mistake number 3, resisting. Even if you think the detention is unlawful, resisting physically can escalate the situation dramatically. Disputes about legality are generally decided later through legal processes. Mistake number 4, consenting without thinking. Many people automatically agree to requests because they feel pressured. Before agreeing to searches or answering extensive questions, understand that consent can affect your legal protections. The smartest thing to do: if police detain you, stay calm, keep your hands visible, do not run, do not argue, do not resist. Ask, am I being detained? If yes, ask, am I free to leave? If the answer is no, remain calm. Follow lawful instructions. Consider exercising your right to remain silent. If the situation becomes more serious or you are arrested, request a lawyer. Final thoughts. Being detained does not automatically mean you are guilty. It does not automatically mean you are under arrest. And it does not mean you have lost all your constitutional rights. A detention is a temporary investigative stop. Police generally need reasonable suspicion to do it. During that stop, you still retain important protections, including the right to remain silent in many situations. The people who handle police encounters best are usually not the loudest people. They are the people who understand the law, because knowing your rights is important, but knowing how to exercise them calmly and intelligently is even more important. Disclaimer: this video provides general educational information about U.S. law and is not legal advice. Laws vary by state, and specific situations can produce different legal outcomes. If you face a legal issue, consult a qualified attorney licensed in your jurisdiction.
That's all for this video. For more information, watch these videos.